after the High Court handed down these two judgments, one of the High Court judges went on to give a public speech. And in that public speech, the High Court judge engaged in an exercise of speculation and said that if we do imply into the constitutional framework of Australia a freedom of political speech, it means that we can also imply other freedoms, such as freedom of associations, etc. And that at the end of the day, the High Court would be able, by a process of implication, create a full-blown Bill of Rights. Now, this is very controversial because you have to understand one basic fact. In Australia, unlike all the other Western democracies, in the Constitution of Australia, we do not have a Bill of Rights. So, when you look at the Constitution of Australia, we borrow a lot of the inspiration from the United States Constitution, and then we grafted that federal model onto British principles of constitutional law. But in the process, the founding fathers of the Constitution deliberately omitted from the Australian Constitution an express Bill of Rights. But this is not to say that Australia is an undemocratic country. In fact, I think it is one of the major democracies of the world. But the way in which the court went about this exercise of exercising an ingenious creativity to create an implied freedom of speech led to this basic question of how do you balance, on one hand, judicial creativity with the maintenance of judicial independence. When the judgments were handed down, the commentators and scholars were split into two camps. One camp said that this is a fantastic High Court. It is the most creative court ever in the history of Australia. On the other hand, other critics said what the court was doing has gone beyond their remit, has gone beyond their role. That the court has basically usurped the function of the Parliament of Australia. The reason for the controversy and the justification offered by the High Court is along the following broad lines. The court said that when the Australian Constitution was created and established, what the Constitution brought into existence was a representative democracy. In other words, the court read an implication into the Constitution that the Australian framework created a representative democracy. Then, from there, they went on one step further. From this implication of a representative democracy, we now can also carry out a further implication that in order for democracy to work effectively, people must be able to exercise their ability to talk about the government, ability to exercise opinion over the choices of policies offered by the government and the opposition. In other words, the court said, if you are to have a representative democracy, there must inevitably be an implication that the people of Australia must be able to communicate between themselves and the people who represent them in Parliament, and also the ability among the people of Australia to communicate among themselves. Now, bear in mind, all this is developed by the High Court, but there's nothing in the Constitution which says that there shall be freedom of political speech. So because of the way in which the court developed this new jurisprudence of implied right, and leading to the compliment or disparagement of the court as the most creative court in the history of Australia, it then led to further comments by other judges of the High Court, and another High Court judge went on to say, in order for the people of Australia to be able to communicate between themselves and the people who represent them in Parliament, they must be able to get together. And therefore, there is an implied freedom of political association. there must also be an implied freedom of political assembly. Otherwise, communication is ineffective. So what we then have was implication after implication. And hence, the High Court judge had said in the speech that if you argue logically along this line, you can create effectively a full-blown Bill of Rights. Now, this criticism has become very intense. And in my view, that if such criticism were to continue, it would have an attrition on the standing of the court and ultimately on the independence of the court. So my view is that there is to be noted a need to accord a balance between the protection of judicial independence and the extent to which a court can exercise creative abilities. Where that line is to be drawn, well, it's hard to say. I'm still trying to develop my thinking on the matter. But as a result of the criticism, which became very intense, the High Court of Australia cleverly shifted strategy. Instead of creating an implication and then building another implication upon an implication, the court said, we must always go back to the structure and the text of the Constitution. And so what the court did was they went through the Constitution and they said there are some sections in the Constitution, in particular 2 sections, which says the people, the members of the House of Representatives are elected by the people of Australia, right? And the members of the Senate are elected by the people of Australia. In other words, the court said, here you are, there is a text in the Constitution which says your representatives are based upon a choice by the people of Australia. And because it is based upon the choice of the people of Australia, the choice therefore provides the textual grounding, the textual foundation for the implied freedom of political speech. And by doing that, the court started to diminish the criticism of the court. And in a major case afterwards, all 7 judges of the High Court came together in a unanimous decision and endorsed this new approach, that henceforth, the implied freedom of political speech in Australia is based upon the text of the Constitution, and the text is based upon the fact that the Constitution dictates that the representatives of the people of Australia are chosen by the people of Australia. To be able to exercise a free choice, the people must have the right to exercise free speech in order to debate the policies of the government and the opposition and to debate the merits and demerits of the politician. I won't bother you with the new test because then the court developed further cases. In further cases, the court developed a more sophisticated test. And in that process, they drew upon the jurisprudence of the European court, the courts of the European jurisprudence on the doctrine of proportionality in order to apply this test as to determine at what stage the freedom has been violated. So basically, the theme of my paper is to indicate as an illustration that when courts go too far beyond their remit and no longer exercise or no longer is perceived by the politicians to be performing a role of judicial interpretation, but rather to engage in an exercise of what they could perceive to be an incursion into the role of the parliament, then the court's independence is threatened. So this paper of mine is to illustrate as an example this conflicting balance between creativity and judicial independence. And I hope that this will be of some relevance to other jurisdictions where they do not have a Bill of Rights. Thank you very much.
Thank you very much, Professor Lee. And now for... Do you want to put on questions now? At the end. We're going to have a comment section at the end, if you wouldn't mind keeping it till then. Can we now turn to an Italian perspective on judicial independence? We're privileged to hear Professor Giuseppe Franco Ferrari, of the University of Bocconi, Milano.
Thank you, Mr. President. I want to thank Shimon Shitrit for the invitation to this beautiful city and university. I hope to return the invitation next year in Milan, if I succeed to work with my university bureaucracy. I have to talk about judicial independence in the Italian perspective. I would start by saying that judicial independence is definitely conditioned by several factors. This morning we heard about the clarity of statutes, for instance, the absence of conflicts of interest, and about, for instance, the treatment of retired judges in the afternoon. In the case of Italy, there is another factor influencing the concrete implementation of judicial independence, which is the historical factor. In the Italian case, the complexity of the historical evolution of the judiciary has strongly conditioned the status itself of judges and prosecutors, and the way the independence of the judiciary has been progressively built up. The unification of the state in Italy came in 1861. At that moment, to give a simple idea, there were 7 high courts in different pre-unitary states. 4 of them were courts of cassation, according to the French model, where the cassation court cannot examine a quaestio facti, but only law violations. There was 1 tribunal according to the Austrian model, and 2 more supreme tribunals following a hybrid model. Only in 1875, a new cassation in Rome was created, which only in 1888 became responsible for all criminal judgments, and only in 1923, which means after fascism, became responsible for the cassation of all civil controversies. As far as the status of judges was concerned, the Constitution of 1848 stated that justice stems from the king and is administered under his name by the judges that he creates, and also that judges were not removable after 3 years of service, though a statute of 1865 admitted that a judge could be removed due to service needs. Judges could be nominated after a public exam, but also directly by government through direct recruiting. Prosecutors were dependent from the executive and were charged with monitoring with the working of judicial offices. From 1861 to 900, in 13 governments, there were 17 judges as ministers, some of them ministers of justice, to mean there was a kind of exchange of positions between politics and the judiciary. And also, passages from judges to prosecutors and vice versa were quite normal and frequent. The last democratic reform was in 1908, when it was decided to abolish any kind of selection of judges other than through public exam. A council of the judiciary was created, charged with disciplinary proceedings and advice about the nomination to main offices. And judges could no longer be removed or transferred to different functions without their consent, a part of cases of so-called environmental incompatibility or harm to the prestige of the judiciary order. In other words, they conquered finally a kind of almost complete independence, and in 1909, an association of Italian magistrates was founded, totally elected. In 1921 and 1922, the judiciary power didn't do very much to prevent fascism to get power. The minister tried several times to activate the prosecutors of the prosecution offices in order to prevent fascist violence like town building occupations, riots, and killings without any success. It was told that independence had prevailed. The Association of Magistrates saluted the fascist taking of power as renewal. But the judiciary was not remunerated for this approach because fascism immediately abrogated the council and the union of judges and created in its place a new council for the judiciary nominated by the minister. And between 1923 and 1926, there were expulsions of about 100 judges due to formally a reorganization of offices, health reasons, or political reasons. Among them, a Roman judge who was accused of having been too diligent in investigating the Matteotti killing, the killing of a Social Democratic member of parliament. In 1926, a ban was approved on any kind of judge association. Later, judges were obliged to swear an oath of loyalty to the fascist regime, and actually this was valid for all civil servants. Of 1,500 university professors, 11 refused, others flew abroad. No judge refused to swear loyalty to the fascist regime. Also, they took part in the creation of the so-called special tribunals for the security of the state. This was the reason why the founding fathers in 1946, 1947 did not trust the judiciary power very much, and they decided somehow to include in the Constitution new provisions with a lot of guarantees for the future independence of the judiciary, like Article 101, justice is administered in the name of the people, judges are subject only to the law. Article 102, the judicial function is carried out only by ordinary judges according to their statute included in the rules of the judiciary. Extraordinary or special judges cannot be created. A statute regulates cases and manners of direct popular participation to the administration of justice because fascism had abrogated popular juries. And also, Article 104, the judiciary is a branch that is autonomous and independent of all other powers. And the independence of the judiciary is guaranteed through the creation of a self-governing body within the judiciary, which is the new High Council on the Judiciary, which is composed for 2/3 by members elected by the judges themselves of the different categories, and 1/3 elected by Parliament in joint session from university professors of law or lawyers with 15 years of practice. The High Council is responsible for assignments, for transfers, for promotions, for disciplinary measures concerning judges, and is presided over by the President of the Republic with the Vice President who is chosen among the members designated by Parliament. It lasts 4 years and cannot be immediately re-elected. This is the complete set of guarantees introduced by the Constitution. We also should add Article 107, stating that judges may not be removed from office, they may not be dismissed or suspended from office or assigned to other courts or other functions unless through a decision by the High Council of the Judiciary taken either for the reasons and with the guarantees of defense established by the provision concerning the organization of the judiciary or with the consent of the judges themselves. In other words, we do have now a complete set of guarantees more or less comparable with those of other more ancient democracies. This is as far as the law in the books is concerned. We have to say something about the living constitution, or the real situation, I mean the law in action. The real problem nowadays, it has been realized in the last 20 years or so, but no real measure has been adopted to confront this situation. The real problem is that the representation of judges in the High Council of the Judiciary is divided into political segments or components. In the Italian political jargon, it is called streams. They are called streams. There is an area which is called democratic magistracy, which is somehow left-wing. There is another area which is called independent magistracy, right-wing, and in the center, a constitutional magistracy, or unicost, which is supposed to be a kind of halfway between right and left-wing. The most important offices, it has been recently recognized by the Advocate General, are assigned according to the political qualification of the nominees and to the majorities existing in the High Council. And above all, the careers of prosecutors and judges are common, so that one can move, work as a prosecutor for decades and then be appointed top judge and vice versa. This problem is probably one of the causes of other problem of the working of the Italian judicial system, like the impossibility. There is a principle in the Constitution which is the principle of compulsory criminal prosecution, which is very hard to implement in concrete terms, because the growing number of crimes and the impossibility of incrimination of all the investigated persons gives a very wide discretionary power to the Office of Prosecutors, absent general guidelines in the American way concerning the preference or a selection of types of crimes to be more efficiently prosecuted. Sometimes newspapers refer of political preferences of the prosecutors, which are supposed to influence the selection of cases and the proposition of further remedies against subjects acquitted in first instance. There are several other problems. The most serious is probably the lack of use of measures other than preventive detention, so that in this moment there are in Italy about 15,000 more prisoners than jail places, so that we have been convicted by the Strasbourg court, and tomorrow is the last date before which we are supposed to remove this problem, which is completely impossible unless the Parliament decide for a general pardon or something like that. In other words, and this is the conclusion in a kind of interrogation form, is the independence of the judiciary seriously menaced by the politicization of judges as individuals? Does the subordination of the judge to law only conceal too wide a discretion nowadays? And as a consequence, is liability of the judge restricted in unacceptable terms? I leave you with this interrogation. Thanks a lot.
Thank you very much, Professor Franco Ferrari. Now, can we save questions until after the final speaker? We have a comments section which is going to be introduced for us, and it would be best, I think, if we kept our questions till then. Our last contributor in the list of participants is Mr. Sergey Mikhailov, who is a candidate for legal science in this our host university, and he's very welcome to address us. Mr. Mikhailov.
Добрый день, уважаемые коллеги. Понимая, какая ответственность на мне лежит за продолжительность предстоящего перерыва, я постараюсь сделать свое выступление максимально коротким, но тем не менее емким. Сегодня очень много говорили о профессионализме судей, и профессионализм мы понимаем обычно как владение судьей необходимыми знаниями, опытом работы, практическими навыками, но в определенной сфере, в сфере права. Я постараюсь взглянуть на проблему профессионализма с другой стороны, с той точки зрения, что судьи, особенно судьи специализированных судов, должны обладать не только правовыми знаниями, но и знаниями в других смежных областях. Конституционный принцип независимости судей, как уже подчеркивал Владимир Владимирович Ярков, обеспечен рядом гарантий, и среди этих гарантий, на мой взгляд, важное значение имеют так называемые специальные юридические. Последняя группа гарантий может быть разделена на две части и включает в себя как организационно-правовые, так и процессуально-правовые меры, которые призваны обеспечить независимость судей в ходе рассмотрения и разрешения дела. Среди процессуально-правовых мер я бы отдельно выделил те положения, которые связаны с оценкой судьей имеющихся в деле доказательств. Оценка доказательств определяется как мыслительная деятельность судьи, которая протекает в установленных законом процессуальных условиях и имеет своей целью установление определенных свойств доказательств. Кроме того, в оценку доказательств в отечественной юридической доктрине нередко включают и правовую оценку установленных судом фактов. Процессуальные законы, Гражданский процессуальный кодекс, Арбитражный процессуальный кодекс прежде всего, определяют принципы оценки доказательств, среди которых важное значение имеют свобода и самостоятельность оценки доказательств судьей. Свобода оценки доказательств заключается в том, что в законе отсутствует предписание относительно достоверности и силы доказательств. Но, на мой взгляд, в контексте рассматриваемой темы важное значение имеет принцип самостоятельности оценки доказательств судьей. Самостоятельность предполагает, что судья, оценивая имеющиеся в деле доказательства, использует свои личные знания, профессиональные знания и жизненный опыт. Таким образом, можно сказать, что совокупность имеющихся у судьи знаний является той основой, на которой строится оценка доказательств, что позволяет рассматривать знания судьи в качестве определенной меры, которая обеспечивает его независимость. Переходя непосредственно к суду по интеллектуальным правам, который скоро отпразднует годичный юбилей своей деятельности, необходимо обратить внимание на предпосылки создания этого суда в России. В их числе, в частности, выступали необходимость формирования профессионального судейского корпуса, который сможет эффективно рассматривать споры в области интеллектуальной собственности, а также повышение эффективности самой судебной защиты интеллектуальных прав. Особенности объектов интеллектуальной собственности таковы, что квалифицированное рассмотрение и разрешение возникшего спора, на наш взгляд, требует наличия у судьи не только правовых, но иногда технических, либо, естественно, научных знаний. Например, председатель суда по интеллектуальным правам Людмила Александровна Новоселова отмечает, что наиболее важным фактором, который повлек создание специализированного арбитражного суда, послужила сама природа подведомственных ему споров, рассмотрение которых требует не только глубоких юридических знаний и умения увидеть реальную причину конфликта, но и оценки технических либо научных решений. Кроме того, в целях усиления специализации суда по интеллектуальным правам арбитражным процессуальным кодексом предусмотрено участие в рассмотрении подведомственных ему дел специалистов, а также право направления судом по интеллектуальным правам запросов лицам, которые являются сведущими в той или иной области знаний. Поэтому формирование профессионального судейского корпуса, который сконцентрирован в одном судебном органе, который способен квалифицированно рассматривать и разрешать дела о защите интеллектуальных прав, это, на наш взгляд, одна из составляющих эффективной судебной защиты этих прав. Необходимость обеспечения деятельности суда по интеллектуальным правам квалифицированным судейским составом повлекла за собой внесение ряда изменений и дополнений в закон о статусе судей в Российской Федерации. Помимо общих требований, которые предъявляются кандидату на должность судьи, устанавливаются дополнительные. И в этом отношении ряд дополнительных требований соответствует тем, которые предъявляются к лицам, претендующим на занятие должности судьи Федерального арбитражного суда округа или арбитражного апелляционного суда. Но закон о статусе судей содержит положение, согласно которому в случае, если вакантной должности судьи специализированного арбитражного суда соответствует несколько кандидатов, учитывается также наличие у кандидатов специальности или квалификации, которые соответствуют специализации суда. Отсюда мы можем сделать вывод, что наличие специальных знаний для кандидата на должность судьи суда по интеллектуальным правам является не обязательным, но желательным. Согласно данным, которые были размещены на официальном сайте суда по интеллектуальным правам, из 18 судей, входящих в его состав, естественно, все 18 имеют высшее юридическое образование, но при этом 4 судей имеют техническое образование, причем в самых различных сферах техники. Это и радиоэлектроника, и электронно-вычислительная техника, и прикладная математика. Если говорить о специальных знаниях, которыми должен обладать судья или лицо, которое привлекается судом для дачи соответствующих консультаций и заключений, то под ними обычно понимают те знания, которые выходят за рамки общеизвестных знаний, принадлежат узкому кругу профессионалов. Как представляется, в той сфере, которая касается интеллектуальной собственности, вопросы права и факта тесно взаимосвязаны. Поэтому установление фактических обстоятельств дела вне их надлежащей правовой оценки невозможно. Именно поэтому, как мы думаем, в законе о статусе судей устанавливается положение о приоритете при отборе кандидатов на должность судей специализированного арбитражного суда лиц, которые обладают помимо правовых знаний, знаниями, соответствующими специализации суда. Естественно, мне могут возразить, указав на то, что недостаток специальных знаний судьи может быть компенсирован участием в судебных заседаниях экспертов, специалистов, может быть компенсирован путем направления запросов специализированного арбитражного суда. Да, это действительно так. Консультации, пояснения, заключения, они способны восполнить недостаток специальных знаний судьи, и с этим тезисом сложно поспорить. Однако здесь кроется другая опасность, и на нее неоднократно обращают внимание как ученые-процессуалисты, так и практические работники. Не владея необходимыми для разрешения дела специальными знаниями, судья так или иначе будет зависим в своих выводах от того мнения, которое было сделано лицом, участвующим в деле и владеющим специальными знаниями. Александр Тимофеевич Боннер применительно к сложившейся судебной практике замечает, что весьма распространенным недостатком практики является некритическое отношение суда к заключениям экспертов. Оценивая заключения экспертов, судьи, не обладая специальными знаниями и даже не имея в силу колоссальной нагрузки возможности и желания попытаться обратиться к специальной литературе, как правило, ссылаются в своих решениях на моменты чисто формального свойства. Подобное положение может поставить под сомнение независимость судьи при оценке доказательств. Поэтому, делая акцент на том, что дело в суде по интеллектуальным правам должно быть рассмотрено квалифицированно, не стоит забывать и о том, что необходимо обеспечение независимости судей этого суда, в том числе теми мерами, о которых я сейчас скажу. Имеется зарубежный опыт в этом направлении. В частности, можно привести пример апелляционного суда Федерального округа в Соединенных Штатах Америки, который рассматривает жалобы на решение ведомства по патентным и товарным знакам и на решение по патентным делам окружных судов. Кандидат на должность судьи апелляционного суда должен быть высокообразованным юристом и специалистом в разных областях техники. Другая модель использования специальных знаний при рассмотрении дела о защите интеллектуальных прав принята в Германии. В Федеральном патентном суде Германии дела рассматриваются судьями-юристами, обладающими юридическим образованием и соответствующей квалификацией, и судьями-экспертами. Это так называемые члены суда, сведущие в технике. Они должны иметь техническое или естественно-научное образование, необходимые знания в области права и стаж практической работы не менее 5 лет. Они являются равными по статусу судьям-юристам. Сочетание специалистов в области права и естественных наук, а также техники, позволит оперативно и профессионально рассмотреть возникающие вопросы. Необходимо отметить, что когда обсуждались законопроекты, посвященные суду по интеллектуальным правам, высказывались предложения о необходимости использования германской модели патентного суда. Однако от этой идеи в итоге отказались, поскольку Конституция Российской Федерации устанавливает, что судьей может быть только лицо, имеющее высшее юридическое образование. Поэтому в деятельность суда по интеллектуальным правам были включены отдельные элементы использования специальных знаний. С учетом сказанного можно выделить два пути, которые обеспечат, на наш взгляд, квалифицированное и независимое рассмотрение и разрешение дел о защите интеллектуальных прав судом по интеллектуальным правам. Первый путь предполагает, что будет введено в качестве обязательного требования к кандидату на должность судьи требования о владении специальными знаниями в области техники или естественных наук. Этот путь нам представляется неприемлем, поскольку приведет к отождествлению функций судьи и эксперта. Второй путь, на наш взгляд, он более обоснован, и он касается распространения на суд по интеллектуальным правам норм об участии арбитражных заседателей. Об этом положительном опыте, о необходимости его возрождения говорил Владимир Владимирович Ярков. Мы полагаем, что этот опыт должен быть использован и в суде по интеллектуальным правам. Спасибо за внимание.
Thank you very much, Mr. Mikhailov. Now, we are about to overrun, but I have it on the highest authority known in the law that we can have another 10 minutes. And I'm going to ask Professor Chandra de Silva, who has kindly agreed to lead the comments this afternoon. He is the Vice Provost of Old Dominion University in Virginia. Professor de Silva.
Thank you, Mr. Chairman. I think I will need only 3 minutes, and I speak only because I'd like to link the 6 excellent papers that have been presented this afternoon to our final session, where we will be discussing the Mount Scopus standards. Because as I see it, all of these papers give some context to and give us an opportunity to enrich the norms for the individual independence of judges that are enshrined in those standards. What I saw in the papers was partly that the perception of the individual independence of judges is as important as the reality. In a sense, Sai Das summarized it well when he said, once a judge, always a judge. And many of the papers deal with the issue about what implications has the activities of judges in areas outside strict judicial activity. So we talked about implications of judges being appointed heads of commissions during and after their tenure, and especially during the period before retirement. We talked about questions relating to employment after retirement. We talked about questions relating to political activity and political speech. And perhaps an area that we could discuss further, but brought up, is the change in the environment in which individual judges work. The change in the environment which was hinted at in references to the internet, in references to the complexity of issues coming in, and references to the kinds of expertise the judges are assumed to have to understand the issues before them. And Mr. Chairman, with that, I know there are other people who want to ask questions, so I'm going to leave it at that. Thank you.
Thank you very much, Professor De Silva. Extraordinary example.
Our friend decided to go television time. Yeah, television time, because they have television time, then public radio time, which is forever, and then you have normal news time, which is in the middle. He decided to talk television time.
Now, are there any other comments? But we must be for obvious reasons. Sir,
I'll be very brief. Professor Lee, at least the three Israelis around this table will understand, fully understand and sympathize with the dilemma, the constitutional political dilemma that you presented to us. In judicial alleged legitimacy and judicial, how did you call it, creativity. My question, I may briefly touch upon it later today. My question is, under the Australian Constitution, is it, at least formally, possible for Parliament, unhappy with a certain judicial Supreme Court interpretation of the Constitution, is it possible, and what does it take, to annul it, to eliminate it by a constitutional amendment or what have you?
The irony is this. In Australia, in order to amend the Constitution, you go through a very complicated process, which involves approval by not only a majority of the people in the whole of Australia at national level, but it requires a majority in a majority of states. So you need 4 out of the 6 states approving a constitutional amendment. And that's why in Australia, one of the most famous constitutional professors described Australia in the following way. Constitutionally speaking, he says, Australia is the frozen continent. In other words, it's virtually impossible to amend the Constitution. And the history of referendums in Australia has shown time and again, whenever a proposal is put to the people of Australia, they always say in Russian, "Нет." No, they won't approve it. So in that sense, when the critics of the court said, this is a matter which requires the intervention of Parliament, Parliament really has very little role to amend the Constitution. Because how do you amend a Constitution when there's actually nothing written to say about freedom of speech? So how can you amend something to get rid of something which is not there? And that's the irony of the whole situation.
I'm sorry. Okay. Okay. Push the button. There was a song. Okay, push the button. Okay. Giuseppe, in Italy, during the fascist time, what happened to the presiding judges, those who were appointed under the old system? What happened to them? Did any of them continue to serve as judge, or many of them resigned?
About 100 of them were removed between 23 and 26.
But removed or resigned?
Or were compelled
resigned.
to retire. Only a few resigned.
Only a few
Yeah,
resigned.
but,
Goodwill.
but also some general prosecutors and some president of the cassation were nominated senators as a prize.
Okay,
Before 1938, when the Senate was abrogated, was repealed completely.
Thank you very much. Sir.
Professor Lee, I want to go back to, and I'm astounded less by the question of the debate over judicial creativity than what it was about, that is the substance. Were there equal criticisms that somehow no one had thought to put freedom of speech into the Constitution, or to create a statutory basis for it? That is, you know, there may not be certain enumerated rights within a constitution, but certainly legislatures have the power to enact them. And I guess I'm somewhat stunned that this whole argument took place over those concepts. You know, we have the whole argument in the United States over judicial activism, and judicial activism is a code for we don't like the substance of how the court is deciding something, but I'm not sure there would ever be a debate or criticism of a court for looking at the issue of free speech in a democracy. So can you comment on that?
Well, number one, you have noticed that I actually studiously avoided the word activism, because a lot of the scholars in Australia, I think, tend to copy the American scholars, and they attack the court using the word activism. But to me, activism is a word which has, depending on which perspective you're coming from. So it is a word which has no real substance in it. I use the term creativity because in one sense, the court was quite ingenious in the way it was trying to enforce, in my view, a fundamental value which need not be articulated. That if you have a vibrant democracy, if you have a hierarchy of values, I would put at the top of it freedom of speech. And that is how a democracy functions. So in my view, if you were to say, why doesn't the parliament go ahead and legislate in ordinary legislation to insert a freedom of speech provision, I think that would be devaluing the value of free speech, because there is only a statutory-based, statutory-founded freedom of speech. If it is by ordinary act of legislation, it can be repealed or amended by ordinary act of legislation. The court, by using the doctrine of implication, has actually entrenched it into the constitutional framework. It's actually part of the Constitution. The Parliament cannot revoke what the court has said unless the Parliament can somehow go through the process of constitutional amendment to revoke or to reverse what the court has said. And that's why I thought it was a very clever way, a clever strategy of entrenching a fundamental value which is necessary in every democratic polity. That is, if you have a hierarchy of rights, to be a vibrant democracy, the people must be able to say what they like about their politicians, to debate their policies, and you don't really need the permission of the politicians to do that. So that is a roundabout way of responding to your question.
Thank you very much indeed. Have we got time for one more? One more, brief.
You must feel you're being persecuted here, Professor Lee. But I just wanted to ask you one more question. I mean, these are fascinating issues, but surely nobody would argue, would they, that this instance of judicial creativity can be defended on the basis of doctrines of judicial independence? It seems to me that they're quite separate.
I never said that it is defended on the basis of judicial independence. I was saying that because of the way in which the court originally established the freedom of political speech, by not referring to the text of the Constitution, it was being attacked, and quite justifiably so, because they are saying that the court was simply plucking the implied right from the air. And therefore, the continual attacks on the court, in my view, led to a diminution of the standing of the court, and therefore diminishing its independence. That is the correlation I was trying to establish. And the court recognized its error, the error of its ways, and therefore tried to go back to the text. And the text of the Constitution were actually in the words that the politicians are chosen by the people of Australia. To have a choice, a genuine choice, you must be able to speak, and that's it. So
Thank
it
you
was
very much
textually
indeed. I
founded.
think we'll end this session now. It's raised matters which are of widespread interest. Oh, no.
Always the power to veto any decision.
This was, I thought we were talking about the independence of chairman on this particular moment, but we'll let that pass.
That's why I say you can overrule anything in this table.
So,
Yeah, my question will take a long time, I guess, because I asked for a tour de table. In my country, in Belgium, a retired judge cannot act as an arbitrator. What about the system in other countries? In France, they may. I know. In other countries, they may. What about this rule of my country?
how interesting. Deplorable habit. Thank you very much indeed. This conversation will continue into our break, I've no doubt. It raised issues which are of widespread interest and importance to lawyers in just about every jurisdiction, with surprisingly unexpected pieces of information such as that which we've just heard. Thanks to all our speakers, and I hope you enjoy your break. Thank you.